Recording in progress.
All right, this is case number 23 CR 142, State of Ohio versus Brandon C. Fuller. And are you Brandon C. Fuller appearing there from the jail?
Yes, sir.
All right, this hearing is being conducted by Zoom. Mr. Fuller's appearing from the jail as indicated. His attorney, Jacob Wagner, is present with him in the jail video room. Representing the state is Assistant Prosecutor King. Now, Mr. Wagner, do you and your client both agree to this hearing being conducted by Zoom rather than his in-person appearance in front of the court?
Yes, sir, Your Honor. I just thought due to the severity of the case, it'd be best that I be with him, but we're fine doing it via Zoom this way, sir.
You're all right with that, Mr. Fuller?
Yes, sir.
All right. Now, the defendant is charged with 5 counts of rape, all first-degree felonies, and Mr. King, on behalf of the state, has the alleged victim or the representative of the alleged victim been notified of the time, place, and purpose of this hearing and the opportunity to be heard?
Yes, Your Honor, the victim representative has been notified and is elected not to appear.
All right. So Mr. Fuller is scheduled for trial, let's see, I think sometime in November. Originally it was September 25th, and then the matter was reset for November 8th on a final pretrial and trial on November 20. All right. Now, the matter was set for hearing today on the basis of the parties having reached an agreement, and I have been presented with a plea of guilty form, Mr. Fuller, which indicates you're going to plead guilty to 3 charges. I'm going to hold this up to the screen. The first page has your name, case number, and a plea of guilty to counts 1, 2, and 3. Do you see that there?
Yes, sir.
You recognize that form?
Yes, sir.
On page 3, there is a sentence about halfway down the page. It reads, "I enter this plea voluntarily." And below that is a line for a signature of defendant. And I'm going to hold that up to the camera and ask you if that is your signature there next to my index finger.
Sir.
And when did you sign this document, Mr. Fuller?
First of the week, was it Tuesday? Was it last? I think it was Friday.
Friday, okay. And when you signed it, did you understand that it's an agreement to plead guilty, which means there's not going to be a trial? The next step in your case would be a sentencing hearing?
Yes, sir.
And did your attorney go over that with you and explain everything to you and answer any questions you had before you signed it?
Yes, sir.
And did you feel you had enough time to fully consider the matter before making the decision to sign the agreement?
Sir.
And is this what you still want to do today?
Yes, sir.
Now, did you enter into this plea agreement voluntarily?
Yes, sir.
And are you proceeding today with this hearing voluntarily?
Yes, sir.
All right, now, as I indicated before, the agreement states on page 1 that you're going to plead guilty to counts 1, 2, and 3. You're facing a total of 5 counts. Each of those are under 2907.02A1B of the Ohio Revised Code, a first-degree felony. Further states that you understand that the maximum potential term or sentence for these offenses are life without parole. There's also an option of 15 to life. And let's see, is there a third option, Mr. King, of 25 to life? Or is it just those 2? Okay, just those 2. So those are the 2 options. And then there's also a possible fine of $20,000. And prison term for these offenses is mandatory. You understand that?
Yes, sir.
All right. Now, life without parole or 15 to life, what 15 to life means is that it's mandatory you serve at least that before you can be considered for parole. Life without parole, which is the maximum possible penalty, means that you could never be released unless you were pardoned by the governor. You understand that?
Yes, sir.
Now, are you facing any felony charges in any jurisdiction other than this case here?
Probably right now, failure to appear.
And where's that?
It's about, as I failed to register in Wilmington.
Okay.
Right before I got here.
All right. So under the law, these sentences can be ordered to be served consecutively. So if you get to 15 to life, that means it could be 45 to life, and if it's life without parole, it means 3 consecutive sentences. If you're convicted of another felony and sentenced to prison for that, that sentence could be added to be served consecutively as well. Could extend your out time if you were eligible for parole. You understand that?
Yes, sir.
All right. Now, under the law, if you are convicted and sentenced to prison on these offenses, once you get out of prison, if you do, then it is mandatory that you be put under 5 years of post-release control supervision under the supervision of the Adult Parole Authority under terms they set. And that means you'll be supervised by a parole officer under those terms. And if during that period of time the parole authority determines that you're not compliant, they can return you to prison to make you serve an additional period of up to 9 months for a single violation, up to half of your prison term for all violations. But if you commit a new felony, then in addition, whatever sentence could be imposed for that new felony case, the judge could also sentence you to an additional period of a year or whatever time is left on that period of post-release control, whichever is greater, for committing that offense while under post-release control in this case, and that would have to be served consecutively to the sentence in that new case. Do you understand that?
Yes, sir.
All right. And again, probation or community control is not possible because this type of offense carries a mandatory sentence of either 15 to life or life without parole. And if it's a 15 to life, it means there's no early release. You have to do 15 before being considered for parole, and then that'll be up to the Adult Parole Authority, not to the court. You understand that?
Yes, sir.
All right, now the charges in the indictment in count 1, I believe they're all the same in terms of wording, but they allege in count 1 that on or about the period of July 5, 2022, continuing through July 5, 2023, in Highland County, Ohio, you did engage in sexual conduct with V, DOB 6714, not your spouse, or B, and they said V was less than 13 years of age, and specifically less than 10 years of age, whether or not you knew the age. And that's a violation of 290702A1B. Count 2 alleges you did the same thing during the same period of time as does count 3. Now, each of those offenses, or those allegations, Mr. King, are separate acts during that period of time.
That's correct, Your Honor.
Okay. All right. So, Mr. Fuller, do you understand what it is that you've been charged with by the state of Ohio, what they said you did, when, where, and how they allege you did it in each of those 3 instances?
Yes, sir.
And have you discussed the evidence in the case, the possible legal issues in the case, the possible defenses you might try to raise at trial, and the possible outcomes of a trial with your attorney?
Yes, sir.
And are you satisfied with his advice and competence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time? I'm sorry, I didn't hear you.
No, sir.
Okay. Have any threats been made to make you plead guilty here today?
No, sir.
Now, on page 2, toward the bottom, there are several lines that are printed in bold and underlined, which are the key parts of this plea agreement, and they read as follows. Defendant will enter plea of guilty to count 1, count 2, and count 3. State will dismiss remaining counts. State and defense jointly recommend 15 years to life on each count to be served consecutively for a total of 45 years to life. Defendant shall be a Tier 3 registered sex offender. Is that your understanding of the agreement?
Yes, sir.
And has anyone promised you anything other than that to get you to plead guilty here today?
No, sir.
Now, under the law, the matter sentence is up to the judge, not to the parties. And so, if you plead guilty here, I don't have to follow that recommendation. I could decide that you should receive a sentence of life without parole on one or more of the offenses rather than the 15 to life. You understand that?
Yes, sir.
And you'll also be required to register as a sex offender should you ever be released from prison in the future. You understand that? I'm sorry?
Yes, sir.
Okay, thank you. I think there's a little bit of packet loss here, so that's why I'm not hearing some of your responses. Our connection's not real good, so just bear with me, please. All right, now, Mr. Fuller, do you hold any license or certification from any state governmental agency that regulates any trade or occupation in this state?
No, sir.
All right, now you have certain constitutional rights you must understand before I can accept a plea from you. First of all, you have the right to have counsel. Mr. Wagner was appointed to represent you. Now that wasn't simply to work the case out, but to provide any defense that could be available to you under the law that you would like him to provide. So if you decide that you do not want to do this, that you want to defend against a charge, he'll continue to represent you, including a trial if that's what you want. Do you understand that?
Yes, sir.
Right now, under the Constitution, you have a right to have a jury trial on these 3 charges, which means that a jury of 12 people would be selected from a group of citizens that live in Highland County that would be summoned to appear for jury duty on your trial date. After they are selected, the evidence would be presented, then they would be instructed on the law by the judge, and then that jury would have to decide by a unanimous verdict as whether or not the state proved your guilt on any one or more of the 3 offenses. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means you give up your right to have a jury trial, and in that case you would have what's called a court or bench trial, which means that the judge would hear the evidence instead of the jury. The judge would apply the law, and the judge would decide whether or not the state proved your guilt. Do you understand that?
Yes.
Under the Constitution, Mr. Fuller, you have a right to confront witnesses against you in open court and to cross-examine them through your attorney. What that means is that the witnesses against you have to come into court and testify in front of you, your attorney, and anyone else is present. After the prosecutor's done asking questions, your attorney asks questions. That's called cross-examination, and the purpose of that is to try to bring out evidence that helps your side of the case. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a right to compel witnesses to come to court to testify on your behalf, the same as the state. So, if you decide to, or if you have witnesses that you would like to appear to testify for you, and you're not certain they're going to come voluntarily, at your request, the court would issue a court order, and that's a subpoena. And then that would force those people to come to court to be able to testify if you wanted them to, even though they didn't want to be here, which is the same way the state's witnesses are forced to come to court to testify against you. Do you understand that?
Yes, sir.
Right now in the Constitution, Mr. Fuller, you're presumed innocent of, you have a privilege against self-incrimination, which means that you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't. It's up to you, and if you decide you do not want to testify, the fact that you did not testify cannot be used against you by anyone at any time during the proceedings, including trial. And in fact, no one's even allowed to talk about it except in one situation. If there's a jury trial, you don't testify. The judge does instruct the jury that because it is your right, they're not permitted to consider it for any purpose. Do you understand that?
Yes, sir.
Now, under the Constitution, you're presumed innocent of these charges until proven guilty by the state of Ohio on every essential element of each offense by proof beyond a reasonable doubt. What that means is that the burden of proof isn't on you to try to show that you're not guilty of these charges simply because you've been charged in an indictment. In fact, under the law, you don't have to present any evidence to defend yourself at trial if you choose not to. But whether you do or not, the evidence or the law requires that the burden of proof will remain upon the state of Ohio to prove your guilt on every essential element of each of the 3 offenses by proof beyond reasonable doubt, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, Your Honor.
All right, now, Mr. Fuller, you originally entered a plea of not guilty. Not guilty plea denied the allegation in the indictment, denied you committed any crime, and it exercised and invoked all the rights I've just described. If you change your plea from not guilty to guilty on counts 1 through 3, that is the complete opposite of the not guilty plea. Guilty plea admits the allegations in the indictment in those counts, admits that they're a crime, that you committed that crime in each count, and that plea waives, gives up all the rights I've described for you this afternoon, except your right to have an attorney, because you always have the right to have an attorney no matter what you plead. But with that exception, your plea of guilty would waive or give up your right to a jury or court trial, would waive or give up your right to confront witnesses against you, to cross-examine them through your attorney, would waive or give up your right to use the power of the court to compel or force witnesses to come into court to testify for you, the same as the state. It would waive or give up your presumption of innocence, because if you say you're guilty, then the state's not required to prove you're guilty. And it waives or gives up your privilege against self-incrimination, because you're saying you're guilty, and that's what's used to find you guilty. You waive a right to file an appeal and any alleged violations of your rights you think could have occurred up until this point in the case. And finally, you subject yourself to being sentenced immediately by the court. Do you understand all of those things?
Yes, Your Honor.
And Mr. Fuller, are you a U.S. citizen?
Yes.
All right. Now, do you have any questions about the charge or the possible penalties on each of these three offenses?
No, Your Honor.
You understand?
Yes, Your Honor.
You have any questions about the plea agreement?
No, Your Honor.
You understand it?
Yes, Your Honor.
And you understand the recommendation on sentence is not binding on the judge?
Do what, Your Honor?
The recommendation as to the sentence is not binding upon the judge.
Yes, Your Honor.
Okay. You have any questions about the constitutional rights I've explained?
No, Your Honor.
Do you understand those?
Yes, Your Honor.
You have any questions about the plea of guilty, what it means, or what will happen if you enter that plea here today?
No, Your Honor.
You have any questions about anything that I've talked about today?
If I plead guilty, will be able to appeal?
No.
No.
No, if you plead guilty, that waives your right to file an appeal. Now, the exception would be if I sentence you to the maximum sentence, which is life without parole, you could appeal that. There may be another limited appeal or a basis for appeal. I'm not sure quite what that would be. But if you plead guilty, you're giving up that right to file an appeal.
Okay, Your Honor.
All right. Any other questions?
Your Honor.
Is there anything you'd like to speak to Mr. Wagner about before we go any further?
Okay, Your Honor.
Go ahead and mute yourself.
Thank you, Your Honor.
All right. Now, Mr. Fuller, it's your decision at this point then to go forward with the plea agreement and plead guilty to these three counts pursuant to the terms that I've just explained to you?
Yes, Your Honor.
All right. And for the purpose of the record, and in order to avoid any issue about merger or anything, Mr. King, could you give me a brief synopsis of what each of the three incidents are in counts 1, 2, and 3?
Yes, Your Honor. So this started out, the victim here, the mother, walked in and caught the defendant anally raping the juvenile. After that occurred, the juvenile disclosed that the defendant had been anally raping him as well as having the juvenile perform oral sex on him for the 12-month period, and there were, I believe, a total of 10 incidents were disclosed.
Okay. All right. So, as to count 1, then it alleges that on or about the period of July 5, 2022, continuing through July 5, 2023, Highland County, Ohio, that you did engage in sexual conduct with V, which is an abbreviation or symbol for victim, alleged victim, DOB 6714, not your spouse, and the said V being less than 13 years of age and being less than 10 years of age, whether or not you knew the age of V in violation of section 2907.02A1B, the Ohio Revised Code, the charge of rape, a first-degree felony, carrying a maximum penalty of life without parole and $20,000 fine, as well as a designation as a Tier 3 sex offender. How do you plead?
Guilty.
And as count 2, which is alleged is the same thing, refers to a separate incident, but it's the same offense and same penalty. How do you plead?
Guilty.
And then there's count 3, which alleges the same act, the same language, but a different act, but the same crime, the same penalty. How do you plead?
Guilty.
All right. The court finds that on this day in open court, the defendant is advised of all his constitutional rights, made a knowing, intelligent, voluntary waiver of the same pursuant to Criminal 11. The pleas are accepted and order filed. Defendant is found guilty of counts 1, 2, and 3 as charged. Counts 4 and 5 are dismissed. Now, since these are mandatory sentence requirements, there's no point in delaying the matter of sentencing or ordering a pre-sentence report, because I only have 2 options, either life without parole or 15 to life. So I will go ahead and proceed with that. Before I do, though, Mr. Fuller, I need to go over on the record your duties to register as a sex offender should you be released from custody in the future. You are hereby designated as a Tier 3 sex offender child victim offender registry, which means that you'll be required to register for your lifetime in person with the Sheriff's Department of the county in which you reside, and I'm going to explain that, and potentially other places. So you'll be required to reside or to register in the county with the sheriff of the county in which you're going to reside within 3 days after going into that county, being released from prison, or if you're going to be there for more than 3 days temporarily. You're required to register in person with the sheriff of the county in which you establish a place of education, if different, immediately upon going into that county. And if you work in another county for more than 3 days consecutively, or more than 14 days in a year, calendar year, 14 days or more, then you must register in that county as well. So you could potentially have 3 counties of registration: where you live, where you're going to a place of education, and where you're working. For purposes of registration for employment, community service or volunteer service is included in that. If you are going to be gone from the county of your residence temporarily for more than 7 days, 7 days or more, then you must notify the sheriff of the dates of those absences and where you'll be going. If you change your residence, place of employment, place of education, you have to provide a written notification of that change to the sheriff or sheriffs of the counties in which you're registered. If it's going to be where you're going to be residing, then or a place of education, you must give a notice of that at least 20 days prior to the change. Now, for employment, you can wait up to 3 days, because you can work 3 days in a county before having to register. And so if it's more than 3 days, then you have to register there as well. If you move into another state, work in another state, or go to a place of education in another state, you must register with the sheriff of the county of that state in which that is occurring, or if they don't have, if the sheriff's not the one that maintains those records, whatever public official does maintain those. You must also provide notice in writing within 3 days anytime you change any vehicle information, email address, internet identifier, or telephone numbers registered to or used by you. Your registration is for your lifetime with in-person verification every 90 days. The earliest, it has to be in person, can't be by phone or internet or anything like that, video, and it has to be in person, and you cannot do that any earlier than 10 days prior to that date. Now, in the event, also if you do plan to travel internationally, then you must report plans of that at least 21 days prior to the travel. If you fail to comply with any of these conditions, then you could be prosecuted for a felony under Chapter 2950 of the Ohio Revised Code, depending upon what the act was, and that would subject you to being, if convicted, sentenced to prison for that offense for a felony. All right, now I'm filling out my name here and the date of this explanation, and I see here a signature. It appears to be your signature yesterday, 10/23/23. I'm going to hold that up to the camera and ask you if that is your signature there.
Yes, Your Honor.
All right, so you your attorney went over these with you yesterday.
Yes, Your Honor.
All right, good. All right, so that completes the sex offender registration notification requirements. So I'll now consider the matter of sentencing. Mr. King, on behalf of the state.
Thank you, Your Honor. The state would just ask that the court follow the joint recommendation. Would note that the state is consulted with the victim's mother, and she has approved of this agreement. That's all, Your Honor. Thank you.
Mr. Wagner?
Yes, sir, Your Honor. Obviously, just in reading the counts and the indictment, Your Honor, the court is very aware this has been a very tough case. Can't believe, I don't know that I've ever asked the court to go along with a 45 to life sentence, but I know that's kind of where our hands are tied, Your Honor. I would just ask the court to go along with the agreement. Obviously, the court probably doesn't have much compassion for my client, but the fact that he has spared this victim going in these events, I would ask the court to follow the recommendation.
All right, Mr. Fuller, is there anything you would like to say?
I just want to say that I apologize and I hope to get the help I need.
All right. Well, Mr. Fuller, as I've said to other people, the next to murder, the sexual abuse or rape of a child, particularly a child under the age of 10, is probably the worst crime that could be committed, in my opinion, in this state. And in some cases, it's worse than murder, because the victims live with this trauma all their lives. Sometimes that can be a very long time, and a lot of them have a very difficult time in life because of that. To your credit, you did take responsibility and did not require that child to go through a trial, and so the court will take that into consideration. And the court will also note that 45 years is a long time, and it'll be that period of time before you'll be eligible for a consideration for parole. And then by that time, hopefully, you'll no longer be a danger to juveniles. So it's the order and judgment of the court as to each count that you be sentenced to a term, minimum mandatory term of 15 years, and to a maximum term of life on each of the 3 counts. And those are ordered to be served consecutively to one another for a total of 45 years to life. The court imposes consecutive sentences. First of all, that was a negotiated agreement. Secondly, the court finds that these offenses were committed as a series of ongoing conduct, appeared to be other instances besides these 3, and that one single sentence would not adequately reflect the seriousness of the harm that's been caused to this victim of the tender years, nor is it disproportionate to the seriousness of the offense, and for that reason the court imposes that sentence. The court has been notified you by the sheriff that you were arrested on July the 5th, is that correct?
Yes, Your Honor.
All right, so that means as of today, there's a total of 111 days of credit against that sentence. Now, as I indicated to you in the plea agreement, upon completion of the sentence, if you should be released on parole, then you will be put under a mandatory period of supervision by the Adult Parole Authority of 5 years, meaning they will set down certain terms, and the parole officer that is assigned to your case will supervise you. And if during that period of time you do not comply, the parole board can return you to prison under the post-release control provisions for an additional period of up to 9 months for a single violation, up to a maximum of half of your prison term for all violations. But if you are convicted of a new felony during that period of time, then in addition, whatever sentence the judge in the new case could impose upon you, the judge could also sentence you for committing that offense while under post-release control in this case to an additional period of a year, or whatever time is left on that period of post-release control, whichever is greater. And if that occurs, that has to be served consecutively with the sentence of the new case. You're also ordered to pay the court costs, which judgment, grant, and execution is ordered. If you don't do that, the clerk of courts can collect that through various means, including levy on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then you could be ordered to do community service if you were paroled or released from and put on PRC, and you could be required to do community service in the county and be given credit for each hour you worked in an hourly rate set by the court. Each hour you worked would reduce your judgment by that amount until paid in full. All right, is there anything further from counsel? All right, you're remanded back to custody then, Mr. Fuller, thank you.